I think we can start, Edu.
Yes, let me share the presentation, just 1 second. Just another second. Okay, here we are.
Yes, so let's start. We are here today to talk about standard essential patents. But before that, I'm going to talk about patent litigation system in Brazil, since we do not have specific rules for standard essential patents or decision on the merits about this matter yet. So I think it's important to have an idea of our patent system. So basically, Brazil has adopted a civil law system. So patent litigations should follow the rules of our industrial property law, which is a federal law enacted in 1996 in accordance with some important international treaties, such as Paris Convention, Patent Cooperation Treaty, TRIPS. So patent litigations should also follow proceeding rules of our Civil Procedural Code, which is also a federal law, recently enacted in March 2016. And this new procedural law brought several modifications in the law in order to expedite proceedings. Then I think you can move on to slide 2, Edu.
Yes.
Oh, 2, no, 3, yes, 3. So we can talk about our court system in Brazil. In first instance, we have the state court and the federal courts. We also have state courts of appeal and federal court of appeals, and up courts we have the Superior Court of Justice and the Federal Supreme Court. Patent infringement cases and or non-infringement declaration actions are filed before the state courts, where non-reproduction of the claims of the patent will be assessed by the judge through a technical cooperation between the patent claims and the alleged infringement acts, which means that a technical appraisal, it is very important. And this technical appraisal should be performed by an expert appointed by the judge. Some states, as São Paulo and Rio de Janeiro, have nowadays courts specialized in industrial property matters, which has been very effective for the stability of our patent system, increasing the number of rulings on the merits per year, and also improving the quality of the decisions, as the judges are more familiar with IP matters, as you can see in slides 4 and 5. Currently, we have 1,837 ongoing infringement actions and 1,037 cancellation actions. And as you can see from the graphic, the numbers of the decisions are increasing each year, which means that the judges are more familiar with this matter, and it's very important to our patent litigation system. The infringement action must be filed on the venue in which the violation part resides or in which the facts of a patent infringement are occurring. Cancellation actions are normally filed in Rio because it's where the patent office is located. Brazilian courts only have jurisdiction in Brazil. So if there are a patent litigation or a patent infringement discussion and in Brazil and also outside of Brazil, it will be necessary to send a rogatory letter to the authorities of the other jurisdiction in order to enforce a decision rendered here in Brazil.
Maria Isabel, let me just add something very interesting. This procedure, rogatory letters, take forever. We had a case that that it is taking more than like 2-3 years to serve the defendant with the summons in another country, because it takes forever. There are a lot of bureaucracy between the countries, but this is what it is. So in this case, it's better to find someone else to summon in Brazil just to move forward the infringement case. Otherwise, it can be stopped for months or even years, trying to serve the defendant with the summons in another country.
Yes. We do not have discovery proceedings here, but it's possible to request an early production of evidence, especially when there is an urgency for some reason in the collection of the evidence, or even a risk that such evidence will be impossible to be obtained during the course of the action. In this type of procedure, there is no discussion. It's really important, this information. There is no discussion on the merits, and defendant is only served to participate of the collection of the evidence. It's not mandatory to send a cease and desist letter before start any proceedings related to patent litigation here. In terms of patent infringement, the patent holder can request the cessation of the illicit conduct and also the payment of indemnification caused by the infringement. If the violation is committed by a company, this is also very important, the company itself will be sued. Its shareholders and directors are not personally liable in principle. Sorry.
I don't know if you would say that, but unless the patentee decides to file a criminal patent infringement, and in this case, the plaintiffs would be the directors or the legal representatives of the company in this infringement case, and could be condemned even to prison, depending on the case.
Yes, yes, but if you are talking about civil liabilities, no, only the company itself. That is. The judge is not obliged to follow the opinion of the court appointed expert, but in this case, in the case that judge disagrees with the opinion rendered by the expert appointed by the court, then the judge should explain in its reasoning why he or she is not agreeing with the expert, okay? He can decide it based on another piece of evidence attached to the dockets. Parts may request for preliminary injunctions, and also parts can agree on the procedure and timetables. In this case, this agreement will be subject to judge approval. For instance, parts can change deadlines if they want to, I don't know, maybe have more time to discuss a technical matter. They can schedule different deadlines. Sorry, do you want to?
And what I would say in this was, this is a new thing because the procedural code, the civil procedural code changed, had a big change in 2015. And this is one of the new big changes for us in the patent area, because now depending on how the parties combine and discuss the proceedings, it is possible to change the steps in a patent litigation, especially when dealing with the technical analysis in the patent, in the claim construction and everything. But some judges, it's important to say, are still reluctant to that because they are used to the former way to handle the proceedings. But this is in the code, in the procedural code. And so if the parties want to do so, it is possible to change the steps and the way to review the case and the technical things in the case.
Yes. Parties can also request for the proceedings stayed when they want to open discussion on possible settlement. In the middle of the litigation, parties can request the suspension of the course of the action to discuss the settlement. Now about cancellation action. Any interested part can bring an administrative invalidity proceeding before the patent office up to 6 months after the grant of the patent. Once the administrative sphere is ended, any patent invalidation discussion should happen before a federal judge at any time during the validity term of a patent. When the granting of a patent is being reviewed in court, the patent office should be included in the action as a co-defendant. In an event, the patent office is allowed to agree in court with the invalidity request. In this case, because of course, patent office should act based on public interest. That's why we can change opinion in court. In this case, the patent office will be plaintiff's assistant, okay? Under Article 56 of our AIPPI law, invalidity can be argued as a defense argument. But nowadays, based on a precedent of our Superior Court of Justices, infringers are filing a separate court action before the federal court to discuss patent invalidity based, of course, on non-fulfillment of the legal requirements or non-patentable subject matter or lack of clear and sufficient description. So infringers are filing separate actions to discuss cancellation. In this case, they can request as a preliminary injunction the suspension of the ongoing infringement action until a final decision in the cancellation action. All patent litigations are decided by a judge in first instance. At second instance, all appeals are decided by 3 justices. There is no jury for patent infringement proceedings in Brazil. The length of a patent litigation proceeding will mostly depend on the complexity of the case and the technical discussion involved. But considering that the courts have implemented electronic proceedings, this can generally last, in first instance 2 or 3 years. At the Court of Appeals, also 2 or 3 years. 2 to 3 years in the Superior Court of Justice in case of a violation of federal law, generally the AIPPI law, the Civil Code, or the Civil Procedural Code. As the Brazilian Constitution does not regulate patents directly, patent cases rarely go to the Supreme Court. So it's important to know also that decisions or opinions rendered by an international entity or foreign courts may be used by parties in the dispute to reinforce their claims. But foreign decisions cannot be interpreted as a case law in Brazil. Judges may refer to such opinions or decisions in their reasoning, but is not used as a case law, okay? It cannot be used as a case law. As patent infringement cases usually arise from non-contractual relationships, arbitration proceedings are limited in Brazil. I don't know, Edu, if you participate in, if you have participated in arbitration proceedings about patent, but I don't know if you want to comment on that. But
no, I
it's
never,
rare.
but it would be very interesting to have a case like this, because it would be possible to choose judges or people to judge the case specialized in the patent area, in the patent field. So this would help a lot the case, especially on the technical discussion. So it would be a very important case, and perhaps this would expedite many proceedings and have a decision earlier than a typical patent litigation case.
Yes. Finally, I'd like to comment that our judiciary power is free to apply the law and our constitution equally for all individuals, Brazilians or foreigners, residents or not, in the national territory without distinction of any kind. So our judicial system is truly independent. Judges do their best to enforce the rule of law, no bias against foreign companies. There are a great number of infringement actions filed by foreign companies against local companies, so there is no problem on that. And chances of prevailing are essentially the same, doesn't matter. I think that's it. Eduardo now is going to talk more specifically about standard essential patents.
So before I move forward, I have a question. Should we wait for anybody else, considering that I'm seeing the audience is basically people from Daniman?
Aconteceu
Amanda?
com a gente também. Aí a Amanda falou que é para ficar falando, que uma hora o pessoal entra e aí pega no meio.
Tá bom, tá bom.
E vai ficar gravado.
Ah, é verdade. Ok.
Isso mesmo, porque senão as pessoas entram, veem que a sala está vazia, está sem ninguém, aí eles saem. Então, pode ir dando continuidade, que disseram que a dinâmica é essa mesmo, o pessoal entra e sai da sala. Tá? Raramente eles ficam para ver uma apresentação inteira.
Tá bom.
Tá bom?
So, tá bom. Let's move on. What's the hot topic in Brazil about patent litigation? The main interesting thing is the preliminary injunction, the way to obtain the preliminary injunction in Brazil. Because I know that in many countries, it is very difficult, it's very hard to get a preliminary API in a patent case, but in Brazil, it seems to be easier to get a PI because the standards for obtaining injunction reliefs are a bit lower here than in Europe and US and many other countries. So it is feasible to get a PI even in a complex case when the technical discussion is complex. So the reason for that is because the procedural code has very basic standards for a PI in Brazil. And the first is a typical standard, which is the likelihood of success. So the parties, the plaintiff needs to prove that the chances of infringement are reasonable. So there is infringement, And even though it is difficult to prove these when the technology is complex, it is possible to do so by presenting technical opinions, and sometimes, depending on the technology, samples of the infringing product, comparing with the technology covered by the patent. So there are some ways to prove, to demonstrate the likelihood of success. And the second requisite, the second standard, is the risk of irreparable harm, which is another typical standard for preliminary injunctions all over the world. So it is a typical one. So in this case, it is necessary to prove that if the infringement doesn't stop immediately, the damages will be irreparable, will be huge, so the party will not be able to repair these damages at a later stage. So this is very important to prove when asking for a preliminary injunction. And the judges tend to be very sensitive to these requisites, and they grant PI when the party succeeds to prove them. And another important thing is the balance of hardships. And this is another thing that judges take into account when reviewing a PI request, because if you prove that the damages to you, if the infringement continues, are higher than the damages to the other party if the PI is granted, you have another very strong argument to get the PI. And now I will show why Brazil is a very attractive, is so attractive as a country, is a so attractive country for patent battles. As you can see here, especially in Rio de Janeiro, I'm not talking about Bahia, because Bahia has 100% of success, but there was only one case, so it's not enough to give an idea about the chances of success. But if you see the Rio de Janeiro, you have around almost 100 cases, and the chances to get a PI is around 60–65%. So it's a high number when you talk about preliminary injunction in a patent case. So many patentees choose Rio to ask for PIs, to file their patent infringement cases. And when you talk about SEP, standard essential patent, here is almost a paradise for the patentees, for the patent trolls, for the ones who want to enforce their patents in Brazil, or even in a road patent dispute is a very interesting place, because if you get a PI here, you can use this as a leverage to an agreement, to negotiate an agreement, a worldwide agreement in a patent dispute, even if the patent if the dispute is taking place in another country or in Europe or anywhere else. So it's Brazil. It's a very interesting place to start this negotiation, or even to start to reinforce the position of one of the parties in this negotiation in a patent dispute. So how this works in Brazil when they file this patent infringement action? Obviously, they don't say that, oh, I have a SEP and I don't want to license in friend terms. I decided to move my strategy here. They don't say that. They basically file a typical patent infringement action. And the only thing they change as compared to a typical patent litigation is that they add a very powerful argument. They say that the patent covers a standard technology and as the patent covered this technology used by everybody, everybody infringed the patent. So they don't need to compare the product, the accused product itself with the patent. They basically say, this company is already infringing my patent because my patent covered the standard. So if the product has to use the standard, otherwise the product would violate the standard rules. And even if you talk, especially if you talk about cell phones or telecommunication products, it is mandatory to use the standard. Otherwise, one cell phone will not talk to the other. So they have to have the same language. So they need to use the standard. So if I prove that my patent covers the standard, this accused product necessarily will infringe my patent. So this kind of syllogism is the main argument for patentees when they have essential patents all over the world, and they come to Brazil to file their patent infringement cases. So, and these, besides that, as Brazilian judges don't have technical background, and most of them are not familiar with patent details, with the patent system itself, it's very easy. They simply say, this guy necessarily infringed because they have to use the standard. So there is patent violation. So my likelihood of success is as simple as that. It's very easy. And most judges believe in these arguments and grant the PI. So this is why Brazil is a paradise for SEPs in patent dispute. And one more important, and which is a detail for the patentees, but it's not for a patent dispute, they try to avoid that. They made auto-declaration for SSO organizations, for standard setting organizations. They didn't say that. They basically say, no, my technology is in the standard because my technology is so good, is so important that someone else, and I don't know who, inserted in the standard. But I didn't say a word that I was auto-declaring that this technology was essential. I only allow because if the technology is good, I want everybody using it. But I have nothing to do with it. I only want to enforce my patent because I want my royalties. And don't talk to me about friend because I didn't make any commitment with that. So this is the argument they use to avoid friend terms in Brazil. So it's a win-win case. They take advantage of the essential technology thing, but they don't want to license infringement terms. This is what they do here. And it's important to say that it's very difficult to counter argue this type of allegation. So usually the strategy for enforcing a patent in a litigation involving standard essential patent is to present a technical opinion, basically saying that the claims, the technology covered by the claims are or is embraced by the standard. So this is what you need. And if you have well-known universities, scholars from these universities saying in a 2-page document that the technology is covered by the standard, it's enough because you don't need to compare the product itself. So this is what patentees do in Brazil. And sometimes they also present the manuals, the documents of the accused products, indicating that they use the standard. But it's not necessary, because if they don't use the standard, if you talk about cell phones, TVs, or many other products, the product will not be allowed to be on the market. So there's no way out. So it's a very simple way to prove the standard. Again, using the syllogism, which is, if everybody use the standard and my patent cover the standard, the infringement is already proved. So this is how these patentees arrived in Brazil, and especially in the courts of Rio de Janeiro, specialized court in Rio de Janeiro, where the chances of obtaining a PI are very high. So there is one thing that perhaps, if the judge is a conservative person and consider that the discussion, even though the argument is simple, if the judge finds that, no, it's still complex, so then, as Maria Isabel said, he will wait for the analysis of a court-appointed expert. So these will probably prevent the plaintiff from obtaining the PI, because the judge say, no, there is no likelihood of success. I want to hear my expert because I don't have the technical background. I need to review better this matter. And if there is no infringement, it may be a shame for me, because I would presume an infringement, and my own expert will say that there's no infringement here. So the cases where judges deny the PI was basically because of the complexity of the matter. So how a defendant can counterattack this very easy and simple argument? Firstly, it is necessary to say that it's complex. It's necessary to remind the judge that even though the comparison is between the patent and the standard, there is a product being accused of infringement. So it is necessary to prove that the product itself is embraced by the patent. So this is a very important thing to remind the judge. But in many cases, it doesn't work. So in order to avoid this hard discussion in the very beginning of a litigation process, it's better to pay attention in the negotiation, in the royalty negotiation. And if things start to go badly, like we will not find a deal, the agreement is not going well, the patentee is not presenting any sign that he will negotiate the case in upfront terms, it's better to anticipate some moves. And this is the best thing to do in a case like this. And how you do that? Perhaps considering to file a DJ non-infringement action. And you have many benefits when you do that. The first is to change the venue. We don't need to fight in a place where you know that there are good chances to lose. For instance, Rio. We can go to another city. We can go to another place where perhaps the judges will be more skeptical about infringement, will be more conservative about the complexity of the discussion. And then if we file firstly, then we can choose the venue. And this is very important. This can be the difference of win or lose a case like this, a complex case like this. So this is something that a potential defendant in a patent infringement case would think about. Move firstly and file a non-infringement action in another jurisdiction, in another place. The second and important as well is to consider to challenge the validity of the patent. Because if we file invalidity action, even before and more importantly, before the infringement case, perhaps you can ask the judge in this infringement case, when it's in this later infringement case, to stay the case, because we will be already discussing the validity of the patent. So when the guy enforce the patent and file the lawsuit and ask for the PI, you can run to the court and say, Your Honor, this patent is already being challenging before the federal court. So we don't know if the patent is valid or not. Why don't we wait for that? We wait for the decision there. Perhaps the patent will be declared invalid and you can simply dismiss the case. You don't need to waste 1 minute in this case. You dismiss. But the chances to stay would be higher if you file the invalidity lawsuit before. So these are important measures to do before being served with a summons for an infringement case. So it's important to pay attention and to know exactly what is happening in a negotiation in an infringement case, in a potential infringement case, in a global negotiation. And another important thing is how we will prove the lack of infringement, the invalidity of the patent. The only way to prove that is using technical opinions. And they take time to be prepared. Everybody knows. Sometimes it takes 3 weeks, 1 month. The scholars have to learn the technology. The draft needs to be reviewed. So it takes a while. So it is important to have time to prepare everything, to have all these papers prepared. So the sooner you start to work in these anticipating moves, the better. So again, it's very important to know exactly where we are in the negotiation of royalties when deciding to move forward with these moves. And just it's important, another important thing is that even though we don't have all these essential patent things in our regulations and laws, we have a few decisions on this. There are some judges who are learning how things work abroad and are bringing these decisions and concepts to Brazil and saying that if there is no friend proposal of agreement or for royalties, I should not grant a PI because it's unfair. So these type of arguments that comes with good faith, venire contra facto proprium, and many other principles in the civil law, judges are accepting them and learning that it's important to balance the discussion, especially when the patentee has a patent with standard things inside it, with a technology that is used by everybody. And in Brazil, we have a few cases. We have around 20 active cases discussing essential standard patents. And we have the patentees are very well known. Divix, WSO, Dolby's, Ericsson, Voice Age, and a few others. So the discussions are being developed in Brazil. So we have more and more discussions. And as I said, judges are learning, and the rationale of the decisions are more and more involving friend things, friend discussions, friend terms, and not only the patent infringement itself, only the comparison between the claims and the product. Now we have more than that, which is good, because the discussions are more, the discussions look more what is happening in other countries, in Europe or in the US, and even in Asia. And this is very important for the development of this discussion in Brazil. So again, just to conclude, we have many patent cases in Brazil, and as I said, Brazil is still the paradise, especially the courts of Rio, the paradise for patentees with essential technologies, because the chances to get a PI are still high here in Rio, but we have some arguments to counterattack these simple arguments, that if the simple syllogism that if everybody use the technology, everybody infringe my patent, and if everybody infringe my patent, this guy there that I'm suing is infringing as well, so I should get a PI. So as I said, it's important for potential defendants to anticipate moves and take these important measures, such as filing DJ non-infringement actions, cancellation actions, or some other measures to neutralize these potential attack and this potential preliminary injunction. And just last but not least important, it's that non-entities, practitioners, non-practice entities, I'm sorry, I wrote NAP, but it's NPE, they don't have any special treat in Brazil. So even for them, it is possible to get a PI. Actually, they get PI in Brazil in courts of Rio. So we don't, the famous Supreme Court case in the US involving eBay, unfortunately for potential defendants, are not applied here. Judges grant PI if they find that the standards are met. Okay, so thank you very much. And if you have any questions, feel free to ask.